Welcome, I'm Joanne Law, Director of Mediation Institute, and I'm really happy to have Chris Erskine with us today. He's going to be speaking about the court-ordered type litigation mediation. So just a brief introduction to Chris. He's a Mediation Institute nationally accredited mediator member and an ACT-based senior counsel. Chris has been with Blackburn Chambers for over 31 years, so he's got quite a longitudinal view of the legal system there and the emergence of mediation as it has. He's had an even longer contribution as the organist at St Paul's Anglican Church in Manuka. So anyone who's ever attended there, you may have had the opportunity to hear Chris, as he's been playing there for 38 years plus. As a mediator with a strong legal background, Chris is going to share his perspective on the differences between the type of facility of mediation that's taught under the National Mediator Accreditation System and the mediations that occur in those court-ordered non-family law mediation context. Before we proceed, and I hand over to Chris, I'd like to acknowledge the traditional custodians of Australia and pay respects to elders past, present and emerging throughout Australia. I come to you from the lands of the Gunai-Kurnai people in Gippsland, Victoria, and Chris is on the lands of the Ngunnawal people in Canberra. So Chris, I might hand over to you now. Welcome.
Actually, I'm on the meeting point of a number of different lands, because it's not just the Ngunnawal in Canberra now, it's the Ngambri, and there's, I think, at least two others who have connections to the area as well. So it's interesting. All right. I hope you can all hear me. If you can't, you better tell Joanne and we'll do something about it. The purpose of this session is to pick up something that I found when I was doing my mediation training some years back, which is that what we're trained to do through the accreditation system has some rather fundamental differences at times with the kind of mediation that's going on in courts and tribunals around Australia. And I thought it was helpful to pick up some of those differences and see what we can make of them. So the starting point for those who aren't aware of this is that mediations are now being routinely ordered in civil cases in courts and tribunals across Australia, and I list here a lot of the courts that are doing them. I would estimate we're now looking at thousands of mediations a year. We must have hundreds of mediators in the legal profession across Australia. Some of them are retired judges and magistrates. Some of them, like me, are experienced counsel. And there are some senior solicitors who are mediators as well. So this is now becoming quite a big deal with the mediations that are happening in litigation. And it's worth our while exploring what some of the differences are. So the first thing I have to say is that I'm not dealing with the family courts of Australia. They're a very different proposition when it comes to mediation, and there's some justifiably specialised training that goes on for people who mediate in those courts. So you can put them out of the equation. And I'm also not dealing with criminal matters because mediation is just about unknown in criminal trials. You can leave that out of the equation as well. But if you're going to deal with all the rest of it, you've got civil litigation and administrative review tribunals across Australia that are having mediations ordered all the time.
And I've just launched that poll just to get a feel for who's in the room and what sort of backgrounds that you've got. Feel free to go on, Chris, and I'll stop the poll in a
yep.
when people
okay.
To answer.
But as I note here, while all courts and tribunals are now ordering people to take part in mediation. They've been going on in litigation for quite some time at the behest of individual parties too. So when I'm talking about mediations in litigation, I'm not just talking about those where the court orders it to happen. I acknowledge that they happen voluntarily as well. Either way, it's now just about universal step in preparing a case for trial. And as a result, pretty well all the courts and tribunals these days have got panels of accredited mediators who are assigned to do mediations on behalf of the courts. And I give the example here, I'm on the panel of mediators for our Supreme Court and our Magistrates Court. We are the two smallest civil courts in Australia, and we have upwards of 100 such mediations each year. So you can imagine how many are being ordered out of the Federal Court or the New South Wales District Court or places like that. It will be in the thousands, I'm sure. And it's also worth noting that as new courts are being built, mediation suites are now being incorporated into them. When mediations began in litigation, we did things like using the courtrooms when they weren't in use as the places to conduct mediations, or the boardrooms of solicitors' offices or places like that. But if I take the ACT courts as an example, where the building there's a new building opened 4 or 5 years ago, we've got a fantastic set of mediation suites. We've got about 3 or 4 conference rooms, and we've got 12 breakout rooms, and they've all got video and telephone facilities. So it's becoming quite a big deal, as you can see. So it's an almost universal step in civil litigation. When are they happening? When courts order them to occur, it's usually when the case is reasonably close to trial. So that's at a point in which the parties have got the case ready, they've collected their evidence, they've exchanged information, they've got the court documents in order and so forth. And in the last lap towards a trial being set, trial date, the court says, okay, go and have a mediation. But there is an exception to this, and it's a significant one, which is a lot of our administrative tribunals like NCAT and ACAT and QCAT, and you get the idea of CAT, Civil Administrative Tribunals, often do them at the other end of the process. So, for example, when you've got, I don't know, guardianship matters, planning disputes, small claims, that kind of thing, a lot of these tribunals often order mediation to happen early on in the proceedings, before everybody has had to knuckle down and prepare all their witness statements and so forth, in the hope that a mediation might short circuit having to do all of that. So there is an exception to this, but even when you've got a tribunal making that kind of early on mediation, at the very least, there are documents on the tribunal file which tell you what the case is all about. And so here I'm giving you a roadmap of where I'm going with this presentation. The main differences to me are threefold. The first is that the dispute's well explained and documented before it all begins. The second is that the parties are usually represented by experienced lawyers. And the third, which you might find unusual to have mentioned it, but it's rather important, I think, if the mediation fails to resolve the dispute, it's going to go to trial, and usually within a fairly short time. So there's quite a focus of the people taking part in the mediation on what's going to happen. So let's tease some of these out. Lawyers will be familiar with the fact that litigation's run with pleadings. And pleadings is, for lay people, is probably a term you've heard, but don't exactly understand what it is. Pleadings are essential court documents and they start a case going. And the pleading sets out the key facts, how those key facts establish a legal right, and what outcome the claimant is seeking. This is a situation in all courts and in most tribunals. If you're going to start a case in one of these places, you've got to file a document saying, this is what my case is all about. In addition, many civil cases now require written statements or affidavits being provided in advance from the important witnesses. So you're going to have evidence in writing as well. And many cases involve experts. So they could be doctors involved in a case where there's been some injury to the person. There might be an engineering issue, whether it be car accidents or equipment or building disputes or things of that kind. Administrative tribunals do a lot of planning cases, and you get expert planners coming in, giving expert reports. A lot of cases involve money, and you might have to have a valuer involved to value property, for example, or you might need to have expert evidence from an accountant telling you what the balance sheets show and so forth. So you're going to have expert reports, and they are invariably in writing. They have to be. So you're going to have them available as well. Noting, of course, as I said earlier, where an administrative tribunal does a mediation early, a lot of this material isn't available. But even there, even in the tribunal mediations, you still get something in the nature of a pleading, and where the tribunal case involves challenging a government decision, a government agency decision, you'll usually have the agency file with all its documents available, so you know what the decision was that's being reviewed and how the agency came to make the decision. So you've still got a lot of information before you start a mediation as to what it's about, and how it's going to be established, and what outcome the claimant wants. For the benefit of people who aren't lawyers, let me give you a hypothetical and simple example. Imagine you've got a case with a plaintiff claiming damages for injuries in a car accident. There'll be a claim document. It's often called a statement of claim, and it will set out some key facts. I'll give you an example here, where the plaintiff was travelling in a car with such and such a registration number on such and such a date on such and such a street at such and such a time. Stopping there, you've immediately got the information about where you were and the date and the time and the details. At the same time, the defendant was travelling in a truck, etc., etc. The defendant's truck suddenly veered into the oncoming lane, hitting the plaintiff's car head on, causing substantial damage. So that's all of a sudden what happened. And so now, if you're coming to a mediation, oh, this is what the plaintiff says happened. The second thing it will then do is say, all of the facts I've just set out mean that the defendant, truck driver, breached such and such a regulation of the motor traffic regulations and was driving negligently. So now you've got a legal basis for the plaintiff's claim. And the document will also set out what the consequences are. So as a result of the collision, the plaintiff was injured and the car was damaged. There'll be particulars of the injury. So let's imagine it was a broken left arm, bruising and shock. There are particulars of damage to the car. So let's imagine that the entire front part of the car required new panels, etc. The plaintiff's incurred medical expenses, and they'll be set out in a schedule. the plaintiff had to take 15 weeks off work, and that's cost such and such an amount in lost wages. So now you've got the consequences of the claim and what the plaintiff is seeking. But there'll also be documents from the other side. So let's imagine we have a defendant in our hypothetical car accident case. The defendant will have a document called usually a defence, and it will follow the same paragraph numbers as the plaintiff's claim. So the defendant might admit travelling in that truck on that street at that time. You know, if I stop there, what that means is that it's no longer an issue that the two parties were on that street at that time in those vehicles. But the defendant might say, I wasn't driving negligently and I certainly didn't veer onto the opposite side. It was a plaintiff who moved across the centre line, making a collision unavoidable. So now you know that there's a dispute about exactly how this accident happened. Was it the plaintiff's fault or was it the defendant's fault? And there might also be an issue that the defendant admits that the plaintiff got injured, but says the plaintiff was actually able to go to work within 3 days of the accident, not 15 weeks. So the defendant's going to put in issue the amount being claimed by the plaintiff. So before the mediation begins, both parties and the mediator in this hypothetical example know the facts of the accident, the competing claims about how it happened, the consequences of the accident, including the dispute about the extent of time off work, and the full extent of what is claimed and why. But assuming it's been ordered by the court once the case has been ready for trial, there'll also be on the file things like these. There may well be witness statements or affidavits from both sides. Not in all cases, but there will be in many. There will be expert medical reports from the treating doctors. And you mightn't be aware of it, but if you've got a case like the hypothetical one I'm using, yes, the plaintiff will have a treating doctor and they will have written reports in about what the injuries are, but the defendant, particularly if it's an insurance company, will have asked for the plaintiff to go and be examined by their own doctor. Insurance companies have panels of expert doctors who do assessments of people claiming injuries to see whether the insurance company's doctors agree with what the plaintiff's doctor is saying. You'll also have on the file schedules of things like medical expenses and lost wages. So you'll actually have the detail of how much money is being claimed. And on top of all of that, if you didn't think that was enough, it is normal and expected in litigation mediation for each party to file and provide to the other side and the mediator a position paper. And a position paper can run for 2 pages. I've seen some that run for 12 pages or more. It sets out the basic facts and the claims. It provides a summary of the argument for that party. It will also set out the response to arguments raised by the other parties. It will have updates. If I take our hypothetical case here, I've seen position papers from experienced compensation barristers which are really exceedingly informative about exactly how the claim is made out and how much is claimed for each particular head of damage. This amount of money is claimed for lost wages. This amount of money is medical expenses. This amount is compensation for the injury, and so forth. So you get a very detailed idea of how the claim is made up. So before the mediation has begun, before everybody has sat down together at the start of the mediation, all of this is known, what I set out on this slide. So you can see that this is a very important difference from the kinds of mediations we learn about in our training, because all of this is done, you don't need to do it again. Indeed, it really is, to be honest, a waste of time going through some of this again. If you were to try and tease out all of this stuff at the beginning of a litigation mediation, the other side has been preparing their case for a long time. They're not going to be persuaded by one party simply repeating what's already set out in the documents. So if you're running litigation mediation, you have to have in your mind that at the beginning, there needs to be a purpose to having everybody together in the room when the mediation begins, because a lot of this stuff might be rather unnecessary. And I'll, in a few minutes' time, when I get down to dealing with how these mediations work, it's not unknown for litigation mediation to begin with negotiations, where you just leave all this bit aside. You don't have a plenary session at the beginning. Now we come to the second difference. This is not universal, but I would say the majority, and probably in the courts, the vast majority of cases that go to mediation have lawyers involved. One or both parties have lawyers acting for them. And these lawyers might include, first of all, experienced solicitors, who are the people retained by the client. Now, these solicitors will have been doing all of the work to work up the case. So they'll have been interviewing witnesses, drafting pleadings, and compiling expert reports, organising expert reports, and so forth. In bigger cases, you might find a number of solicitors turning up. I had one a few months ago where I think we had 4 solicitors turn up for one party. It was quite extraordinary. It was commented on by the other parties. But you certainly might have more than one, because the case might be so big that there are aspects of the case that maybe a junior solicitor has been working on a particular part of it, or a paralegal's been doing some research, something like that. And then, in many cases, you'll also have a barrister, sometimes 2 of them for each party, who have been briefed to run the case in court. They tend to come in often rather later in the proceedings. So, for example, I am briefed to act on behalf of a client in a mediation that's happening next week, where I have only just got the brief yesterday, but the solicitor has been working on it for 6 months. So the barristers sometimes come in late in the piece, but they'll still have been looking at the case in detail, and they will be looking at it in particular from the perspective of how it's going to end up being run in court if it gets to trial. So they're looking at how it's going to get presented. The lawyers are going to do most of the talking in a mediation. They'll be well across the detail. They'll be across the key disagreements. They'll be well aware of the underlying legal principles. And most clients, let's be honest, are terrified of having to say something in these cases, and they're much happier having somebody else who's experienced in being an advocate paid to do all the talking and explain what the case is about and answer the matters raised by the other side. So the people taking part in the mediation, probably 95% of the time, will be the lawyers, and the clients will be sitting there listening. But let's also be honest, lawyers can sometimes get in the way of a settlement. Some lawyers are very keen to run cases in court because they feel particularly confrontational, or they're a bit more gung-ho than the clients are. And if you see this happening, you may have to see if it would be a good idea to get the clients to say something. But the flip side of that is, it's not the role of a mediator to interfere between a client and a lawyer. That's between the client and the lawyer themselves. So you've got to be careful if you find a situation, not to accidentally undermine the relationship between the client and their own lawyer. And so we come to the third difference. And this one you might think is a bit of a surprise, but the majority of mediations in litigation happen when a trial date's already been set. If I take the examples of court mediations that I'm involved in the Supreme Court and the Magistrates Court, one of the first questions I ask people is, have you got a hearing date? And I will usually be told that it's about 4 or 5 weeks' time. So that means that when you start the mediation, everybody in the room knows that if you don't settle it, there is going to be a trial coming up, and within a fairly short time. Now, this has some important consequences for you to think about. The first is that the person who's making the claim has already decided a long time ago that they're going to go to court to get this sorted. They've launched the case, they've filed the documents, they've hired the lawyers, they've done all these things, so they're already committed to resolving it in court if mediation doesn't work. It's already well prepared in most cases. And if it doesn't succeed, there's going to be a resolution one way or the other. And that's important because nothing so focuses your mind as the realization that you're going to get cross-examined in 3 or 4 weeks' time on oath before a judge in a courtroom. And once people start to realize that, the whole process of going to court suddenly becomes very serious and very real. And so they're rather more interested in seeing whether the matter might resolve. All of which says that there's a very different dynamic for litigation, mediation, from the mediations that we are trained to conduct through the mediation training we have to do. First, because before the mediation begins, pretty well everything about the case is known. Occasionally you'll come across a case which has been poorly prepared. I had one last year where I started asking a few polite questions in the opening session, and within an hour the parties had decided amongst themselves that the case actually wasn't ready for hearing and they adjourned the mediation. That's unusual, but it can occasionally happen. The vast majority of mediations, the opposite is the case. Everybody on both sides knows what the dispute's about and how it's going to get proved. The second difference is we've got people involved who are expert advocates, who know the case, who can argue the points out if they have to, but who are ready to explain and advocate for their particular side. And thirdly, we have a deadline coming up. If it doesn't get resolved, it's going to get resolved in a different way. And that focuses people's attention on trying to settle it. Now we have a complication which happens not infrequently in civil litigation, which is that you've got more than one defendant. For example, you've got a workplace injury. A worker comes to court saying, I was doing my job and I got injured when this machine fell on me. Okay, so the employer says, yeah, that's true, but the reason the machine fell was because the person who manufactured it did a bad job of manufacturing the equipment or didn't look after it properly or whatever. And so I want to sue them in return or in turn for the fact that this accident happened. So now you've got two defendants who are defending the one claim, where the employer is saying it was the person who manufactured the equipment, and the manufacturer is saying the equipment was fine, it was the employer who didn't train their staff properly. So now you've got a further issue muddying up the waters. Another example, which happens not uncommonly, unfortunately, in things like car accidents or injuries, is that the person who was injured has a previous accident which caused injuries. And there's a question whether the current injuries are entirely or partly caused by the first or the second accident. And if so, if it's both of them, how much of the current injuries are caused by the first and how much are aggravated by the second? And where you've got two different insurance companies involved in each accident, you've now got two different insurers arguing the toss about how much each of them is liable for. And what happens in these cases is that you have to conduct a mediation inside the mediation between the defendants in order to get an agreed amount to offer to the claimant. The mediation inside the mediation can sometimes take at least as long as the mediation between the plaintiff and the defendants. So in these situations where you've got three parties, the mediation might actually take twice as long because the plaintiff's going to sit around for a couple of hours while you mediate between the defendants about how much each of them is going to offer to the plaintiff in order to resolve the plaintiff's claim. And sometimes the defendants will take different positions. So not just a dispute about how much they're going to offer, how much they're responsible for, but sometimes you'll have, say, one insurer saying, I'm going to offer this amount and no more, and the other one's going to say, I'm prepared to offer 25% of whatever the plaintiff gets because that's my share of what it's worth. So that makes it even more complicated trying to come up with a common position between the defendants that you can put usefully to a plaintiff to try to resolve the case completely. There's another complication which shouldn't happen but does, particularly with government agencies and more commonly with insurers. They will sometimes send to a mediation a representative who doesn't have full authority to agree to a settlement. Now, the courts say this shouldn't happen, and the court directions always require that the people who go to a mediation have authority to settle. But not all big organisations obey this. I've had mediations where the person in the insurance company who is authorised to agree is not present, and they're available at the other end of the phone, where the hapless insurance rep at the mediation has to say, can you give me 15 minutes, I've got to go and talk to my boss, and scuttles out and rings their boss back in Sydney or wherever and explains what's going on and sees how much they can offer. This causes problems for mediators because you've got everybody present to do a mediation, everybody's keen to get started, but if one of the parties isn't fully authorised, do you postpone it? Do you keep going, hoping that authority will happen? It's a real issue, and I think the courts need to be a bit better involved in situations like that, in ensuring that people actually obey the direction to provide people who have got authority to settle. All right. So I've set out the differences between litigation mediations and the mediations we're trained to do. So how does this play out in practice? First of all, the opening session is often brief, and sometimes it doesn't happen at all, and you get straight down to negotiation. That's particularly the case in what I might call routine injury cases, car accidents, medical negligence, that kind of thing, where you've got counsel on both sides who do these cases all the time. You've got solicitors on both sides who do these cases all the time. They know what the medical evidence shows. They know what the usual range of damages is for these kinds of injuries, and it's the most efficient thing to do is actually to get started on the discussion. But one of the things you have to work out right at the start is, if this case is going to be resolved simply by paying money, so if it's just damages, what are you going to do about the legal costs? Because most courts will order legal costs as well. And the legal costs can be the subject of their own dispute between the parties, where the one side has spent a lot more than the other on preparing the case for trial. Are all those costs reasonable? But they should all, the legal costs ought to be included as part of wrapping up a settlement. So you have to work out very quickly at the beginning how you're going to start exchanging offers. You're going to have offers on the basis of legal costs being additional. So, you know, the defendant will offer $100,000 to the plaintiff plus costs, or is $100,000 going to be including the amount of costs? In which case, there needs to be an exchange of information about what the costs are and what they're prepared to agree to, so that you can then negotiate on the same basis. There are some firms and some government agencies which say that they will not negotiate on an inclusive basis. That is, legal costs will be dealt with separately. Not all defendants will agree to that. And you can also understand that there's a strong incentive for parties that are going to resolve a matter to resolve the legal costs at the same time. Otherwise, you're going to settle the payment, but you then got another argument opening up about how much the legal costs will be, and that's going to take 2 months to settle all by itself. So you've got, this is actually a significant issue in some mediations as to what basis you're going to be exchanging offers. But you also need to know that in some litigation mediation, it is actually a bad idea to have the parties present in the same room at the same time. And I give you two examples here. Sexual assault cases, so things like all of those awful cases with people suing church bodies and so forth for sexual assault happened years ago. Harassment and bullying cases are another one, where there's a really bad, angry, problematic personal relationship between the parties, and they shouldn't be in the same room as each other. Many years ago, I did a mediation for a party who I thought was reasonably sensible, where the other party was his estranged wife. It wasn't a family law dispute, it was a commercial dispute where they both happened to have been shareholders and directors in a particular business. And the mediation was tumbling along. We've been exchanging offers and we come to a bit of an impasse. And so my client said, why don't I go and talk to her? And we thought, oh, okay, yeah, that might work. And the other side said, yeah, that could work. What we didn't know was that he was so angry that when he got into the same room as his ex-wife, he just harangued her and had a stand-up fight with her. It was really quite embarrassing. Brought the mediation to an end straight away. So you just need to be aware that occasionally you'll come upon a mediation where putting people together in the same room is a really bad idea. In those sorts of mediations, Zoom, Teams, and the like are actually useful because you can still have everybody talking and available on the screen, but they don't have to be in the same room. They can mute each other. They can turn the screen off when somebody that they don't really want to be together with is talking and so on. So sometimes doing them in the way we're doing this presentation can be a good idea. it's one way of dealing with that kind of problem. But not all litigation mediation is resolved with money. Sometimes something else might be needed. For example, if you've got a workplace dispute where there's employment issues or something like that, maybe an apology or an acknowledgement of harm caused, or a good reference if they're going to try and get another job. If you've got a planning dispute in a tribunal, maybe you can discuss something like moving a wall or shifting the proposed building 1 metre further away from the side fence. Maybe something creative like that might do the trick. So sometimes you've got to explore other things apart from payment of money. But to be honest, the vast majority of litigation is solved by awarding damages. Let's assume your mediation doesn't resolve the whole thing. Is there something in the case that you can resolve so that at least that doesn't have to be fought out at trial? Can you get the defendants to agree on a common position in the court? Can you agree on a particular issue no longer being in contention? At least you might be able to shorten the trial that's coming up. If you have actually ended up resolving it, put it in writing before everybody leaves. This is absolutely fundamental. You see these ads on TV for insurance claim regret, and it's even more common that parties walk out of a mediation and that might think, geez, I shouldn't have agreed to that, should I? So you need to sign people up before they leave the mediation to an agreement, so they're then committed to it. This is not as straightforward as it sounds. Sometimes you are able to write out all the terms. So if it's simply the defendants to pay the plaintiff $110,000 plus costs agreed at $25,000, you can put that down on a piece of paper very easily. But sometimes there'll need to be extra terms. There might need to be a clause saying that this resolves all matters in dispute on this particular issue. There might be some procedural matters, the payments to be made within 28 days to this bank account or whatever. In those situations, you might be able to agree on the fundamentals, put that in writing, and get people signed up, and they agree that the detail will be put in a deed to be signed later. But you also get some experienced solicitors who turn up to a mediation with a laptop and with a boilerplate deed on their laptop ready to go. So if you do end up with it being agreed, they can work out the deed that will give effect to it within a matter of minutes. One of the benefits of modern technology, of course. And if that's the case, then take the 10 or 15 minutes, get it printed out somewhere and get it signed up. But it will need to get signed up. That is really what I wanted to say. So now I think it's open to questions.
Yes, I do have a question. So you're doing the mediation, you do have the lawyers on both sides and that. And I get the gist of it because you have all the information, and that's why you go to negotiation and then some into the agreement, because all the hard work's done. But my question is, when do you jump in and ask a question? Because you were saying that the two lawyers are talking once amongst each other and that. So when is your turn to jump in and start talking?
Look, there's no simple answer to that one.
Yeah.
I have to say the majority of mediations that I do actually have an opening session. But because of nothing else, I might have, for example, a plaintiff who's never been in the mediation before, and I need to explain to them that mediations are confidential, and if I have a private session with you, what you say to me is not passed on and so forth. So sometimes that has to happen. if you're going to run an opening session where you do invite the parties to say something, and there are some cases where that's not a bad idea, even though it's all set out in writing, you'll do it in a staggered way. So the plaintiff's lawyer will speak for 4 or 5 minutes explaining what the case is about or the key issue, and then the other side's lawyer will speak. You, as a mediator, you certainly make sure that there's an opportunity to explain things to the other side. One thing that can sometimes be useful is perhaps the converse of what I said in the presentation, which is you get the two lawyers to talk to each other.
Yeah.
Sometimes that's quite useful, because if they sit down and have a discussion,
they negotiate then.
They can negotiate, yes, but they can also sort out an issue that might be in contention between them or that needs explanation. You've got various possibilities as to how to do that. But I have to say that the converse is I've had a few mediations with personal injuries cases where the real issue is how much, where you've got very experienced counsel acting on both sides. And there are some where the mediator just sits back and reads the paper, because the two barristers will sort it out between them in 25 minutes. You know, that's the ideal from the mediator's perspective. You get paid to do nothing much. But it doesn't happen very often, but it does sometimes happen. So every mediation is different. I can't give you a foolproof answer to your question.
Yeah, for sure. Yeah. Okay. So that's interesting, and it's getting all the work done for you, and then jumping, like you're saying, the two lawyers have their say, and then if you have a question and that, you can jump in and just say what the difference is. And
I get a lot of lawyers, and when I've been acting for a party, I feel much the same way, where there is a real sense that the opening session where you get a chance to explain your case is really a waste of time. And if I am acting for a party and I have to do an explanation, I will say, look, I'm not expecting to persuade you on the other side. This is simply explaining this particular aspect of our case. But the reality is it would be almost unheard of. If a case has got to the point where you're having a mediation with a trial coming up in 3 or 4 weeks' time, it would be almost unheard of where you will drop something into the conversation that completely changes the other side's understanding of what the case is all about. If that's happened, then something's gone badly wrong with the preparation of the case.
Information is not good. Sometimes,
Looks like Sybil's got a question as well. Is that for you, Sybil, or?
Oh, yeah, I do. Thank you. Thanks, Chris. A really interesting presentation. I'm based here in Canberra as well. A bit cold today.
No, it's quite sunny outside.
It's sunny, but chilly. So in your experience, what percentage of mediations are successful and what percentage still progress to litigation?
I couldn't give you figures, and it's a little bit random. So I mentioned, for example, I'm on the panel for mediations, and the way the two courts work is they give you a week's worth of mediation, so 2 a day for a week. So that's 10 mediations you're going to do in a week. The most recent week I did for the Magistrates Court at the start of the year, I achieved a first, which hasn't happened to me before, and which has almost never happened in the court's experience, where all of them settled. But that was so unusual that it caused surprise all round. I can give you a rough idea, which is I think over half will settle. And the ones that don't settle, because the hearing date is still 3 or 4 weeks off, sometimes they can settle at the door of the court. I would think you end up with 90% of the claims that start in a court being resolved before trial. It'll be of that sort of order. And perhaps half of those will occur at the mediation. And if we're going to be brutally honest, for a lot of these resolutions, they were going to happen anyway. The mediator hasn't added a great deal. What they've done is to have a formal bringing together of the parties in a formal mediation where there's an opportunity for the parties to resolve it themselves. So if I was going to be brutally honest, I would say that mediators are useful in probably more than half, but less than all, of the successful mediations, because they were going to happen anyway.
Yeah, and do you see government departments and agencies, are they more likely to settle at a mediation than their private sector counterparts or private individuals?
I don't think there's a great deal of difference. The reason I mentioned government departments in the comments I made earlier is that they've got different considerations sometimes. For example, in the federal sphere, I think it's still called the finance directions, set out the amount that a person at a particular level in a government department is allowed to settle a case for. So if your case is going to go over that amount of settlement, you might have to involve somebody else who's back in head office, who's higher ranked than you. But government agencies, I find, are quite good at making sure that the person who turns up has got the authority to settle up to what they expect the figure to be. But if it goes over that figure, they're going to have to ring back to someone more senior in their own office to get authority to do it. The very first mediation I took part in involved an officer of a federal department who had a huge claim for workplace issues. It was running in the hundreds of thousands of dollars. We ended up, in order to settle it, with the secretary of the department coming to the mediation in order to hear what was going on and to approve the settlement, because it was so big. I have to say that's pretty unusual. And I'll go further than that. It's unique. It's never happened to me since.
Yeah, thank you.
But you do get the same issue with insurance companies, and unfortunately there are some insurers who are worse than others, where they send someone to the mediation who simply doesn't have the authority to settle it for a figure that's realistic. So if the plaintiff is going to settle it for $100,000, the person who turns up for the insurance company might have authority only to settle it for 30 or 40, and everybody knows it is worth more than that. So they're then going to have to involve someone back in the insurer's head office. That's really annoying when that happens.
So is that just a ploy then that they do?
Sorry?
Is that just a ploy then, to throw a spanner in the works? Because it's not authorised, because they're not authorised. And that, I get confused with the organisation of people not authorised to come in and, give an unrealistic value.
Yeah, look, it might be a ploy. I think there are some cases where it probably is. There are some where insurance companies are really busy and they know it'll settle at some point, and they really don't want one of their senior staff having to, say, fly to Canberra if they're doing a mediation here, because their head office is in Sydney and they've got better things to do than spend the whole day travelling for a mediation. But yeah, sometimes I think it's a ploy. Sometimes I think it's just not enough staff doing too much work.
Well, thank you. I've just got a question in the chat from Dinesh. He may not be able, I know he's been having problems with the internet. Have you had any lawyers that were unhappy that you wanted to conference with the parties without them present? I know mediators.
I don't do that very often, and I've only seen it once in a case that I was involved in for a client. I mention it simply because it is a possibility for you as a mediator, but it's one that I would caution you before you do it, that sometimes it might be the only tool left. And it also is where you have to be careful not to come between the lawyer and their client. So if you propose that, you need to get both sides to agree to it first before you actually try and do it, because one client might say, no, I don't want to talk to the other person, or I don't want to do it without my lawyer present because I trust my lawyer and I've been working with them for years and so on. So there might be very good reasons not to do it. Yeah. So if you're going to do it, get agreement first. The first time I saw it happen, where I was acting for a client, I had actually come to the same conclusion as the mediator, which is that the lawyers on the other side were getting in the way of settling it. And so when the mediator suggested it, I said, yeah, I think that's a good idea. And the other side's lawyers did agree, but I think they were a bit hesitant. But they did agree, and the two clients sat down with the mediator and they settled it in 20 minutes.
Yeah, but it'd be much more common that the mediator would speak with the lawyers apart from the clients.
Yeah, and let's not make this lawyer bashing exercise. No. For the most part, I think lawyers and mediations are useful because they not only understand the complexity of running litigation, and litigation can be complicated, but they're also, for the most part, experienced in advocating for their client. The client might be tongue-tied or might be nervous or might know the whole thing, and the lawyer might actually do a better job of negotiating a reasonable outcome. And I also have to say that most litigation lawyers, in my experience, most but not all, are acutely aware that litigation is a mug's game and that the outcome, no matter how good your case is not 100% certain. And running a case in court is a risky business and costs clients a fortune. So if you can actually settle it for less than you wanted now and get on with the rest of your life, for heaven's sake, take it. So in my experience, most lawyers encourage settlements. It's just sometimes you come across, in the minority of cases, lawyers who really would like to run the case in court.
Yeah, and occasionally you get clients who are very concerned about the principle.
That's from spare us some litigation with clients who think it's a matter of principle. The only people who win in cases involving matter of principle are the lawyers.
Yes, I would tend to agree with you on that. I'm just mindful of time, and it's been really, really interesting, Chris, and I guess an insight into some of those differences. Would you say the sorts of mediator skills that we train in the basic training are useful, or really not? Some of that
when I was doing the training, I was actually feeling a bit rebellious because I thought it was unrealistic. But having had the benefit of some of the training about empathetic listening and things of that kind, I've come to realize that actually the training is useful, and it's something that I'm, in hindsight, glad I had. I just wish when I was doing the training that there had been an acknowledgement on the part of the trainers that not all mediations fit the type of situation that we're being trained for, and that some of these skills might end up not being used very much. But as I say, things like the empathetic listening and things of that kind, I've actually found quite useful, and sometimes in the mediations themselves. For example, that one I mentioned where last year, where I asked some questions at the beginning, I was using the techniques I'd been given about how you ask questions and making sure you ask both sides of a dispute. But it was, I think, part of the reason the parties came to realise for themselves they hadn't done a very good job of preparing it on both sides was that I'd asked an apparently innocent question and they'd come to think, we've missed something, haven't we? It was their own realisation rather than my advice to them that made them realise that maybe they need to go away and do some more work.
Yeah, absolutely. That can be very, very powerful, much more powerful than as a mediator if we're making suggestions.
Yeah, yeah.
So look, thank you so much once again. We have recorded this and we'll make it available to those that registered. Are you comfortable for this to be shared more widely?
Yeah, that's all right. Yeah.
Excellent. I'm sure those that didn't will be very happy to get more perspective on this. And so once again, thank you. I think you are part of the network, so if people did want to go connect with you, hopefully you'd be open to that.
Sure.
Thank you. So I'll just end the recording.